he tells you. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, no person time to visit with the Appellate Division. Draw near, give your attendance, and ye shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. I'm going to call the calendar. I'll be calling cases and indicating the time that has been allotted for oral argument. Please listen carefully. People versus Ceballos, 8-2 for the appellant, 8 for the respondent. O'Farrell versus Caliber Home, that's submitted. 2 cases, A. Amir, they are each marked submitted. Santos versus Townsend, appellant gets 3 and 1, the respondent gets 3. Valdez versus City of New York, the appellant has 5 and 2, and the respondent 5. Mendrisky versus Nisha, that's submitted. People v. Geneva Brown is submitted. Michaels Corp. versus the Port Authority is submitted. People versus Charity Finch is 5 and 2 for the appellant, 5 for the respondent. Bankers Conseco versus KPMG LLP, that is 7 and 2 for the appellant, 7 for the respondent. DeGraw Construction Housing versus HPDC2 Housing, 3 for the appellant, the respondent is submitting. Ramos versus Goldberg Scudieri, 3 for the appellant, 3 for the respondent. Niche Music versus Orchard Enterprises, 7 and 2 for the appellant, 7 for the respondent. Curacao Oil versus Trafigura, 7 and 2 for the appellant, 7 for the respondent. People versus Abreu is submitted. Cabrera versus Ahmed is submitted. Halpern versus White is submitted. People versus Abraham Cruz is submitted. In re Sharon Burstein Green, 7 and 2 for the appellant, 7 for the respondent. U.S. Bank versus Olatunji is 3 for the appellant, 3 for the respondent. And finally, Doe versus Doe, 7 and 2 for the appellant and 7 for the respondent. We are going to call the case of In re Sharon Burstein Green out of order. We'll call it first. I'm recused on that case, so if you'll wait just a minute, and Justice Singh will be vouched in. Thank you. Okay. You're good.
Whenever you're ready, Counselor.
Thank you, Your Honor. Good afternoon, and may it please the Court. My name is Allison Basunder on behalf of the cross-petitioner appellant Peter Green. Before I begin, I'd like to thank the panel for the opportunity to appear in person for this argument today. This is a guardianship proceeding where my client, the appellant, is and has been married to Sharon Green, the alleged incapacitated person, for 30 years. And he has raised her three daughters.
Counsel, okay, I have a question.
Yes.
I'm over here. The question is, I know this may be the whole of the record, but I'm curious, where is Miss Green right, I'm over here. Sorry. Where is Miss Green right now?
Ms. Green lives at home with my client, Peter Green. She has been in her home, I believe, since nearly the commencement of the guardianship
Okay.
proceedings, since she has been discharged from the hospital.
Okay, because I wasn't clear because where it kind of left off, that she was in the hospital when this proceeding was, I guess, started or was in the middle of the proceeding and all that, but she's home now, right? Okay.
Yes, she is.
She has, I guess, the 24/7 care being taken care of. There is a plan in place for her?
That is correct. I know that at the time that Fern Finkel, who was nominated specifically to provide as personal needs guardian, that she had put in place 24/7 care and had built upon the plan that my client already had in place. I am not sure the specifics on what has changed since Paul Medeiros has been in place.
And when Ms. Finkel was appointed, there were no, I mean, I gather from the record here, unless, correct me if I'm wrong, both sides were okay with this?
Both sides nominated Fern Finkel and Fern Finkel specifically in an attempt to compromise, and on the one thing that all the
As a
parties
person,
agreed.
guardian of the person.
As the guardian of the person, but that was a nomination. She was not a nomination on the Part 36 list, but she was nominated for her specific unique characteristics, and because, at least on my part, for my client, she had established a rapport with him. She treated him with dignity. She communicated well with him.
So he liked her. He
Yes.
got along with her.
Yes, we did.
So, Counsel, I want to be clear. You are not contesting the fact that Ms. Burston is in need of a guardian. Is an incapacitated person? Is that correct?
So those are two separate questions. We compromised on the issue of incapacity. That is correct, because it appeared that the judge was bifurcating the proceeding into functional limitations and the question of incapacity, but Article 81 does not turn on incapacity alone. We do contest that the guardianship was necessary, and the nomination to agree to Fern for reasons that involved, among other things, the fact that my client did not feel that Sharon would have wanted, being a very private person, wanting all of that brought out in court, and in an attempt to compromise as part of an overall attempting to compromise the whole proceeding. We do contest that the guardianship is necessary, which is the second prong that the statute requires.
So you do contest it. And what's the basis of your contesting? Is this because she executed the various documents? Is that the basis of your position?
That is essentially it in a nutshell, Your Honor, that regardless of whether or not she was incapacitated, the reason that we didn't think that it was worthwhile or beneficial to Sharon to contest incapacity was because it was, in this case, in these circumstances, it was moot. She had sufficient available resources under the statute, and that's under 8102, and it directs you to 8103E, I believe, which is the definition of sufficient resources, and Sharon Green had them. She had almost everything listed in sufficient available resources: the power of attorney, the healthcare proxy. She had trusts established by her mother for her benefit, one she had established in 2001. And the advance directives she had executed on June 3rd, 2015, 5 years before the guardianship.
But was there not an issue in terms of her care? I mean, you just mentioned the fact that Ms. Finkel, when she was appointed, she got along well not only with your client, but was there not also testimony, evidence that she did provide for 24/7 care, and that actually Ms. Burston, to some extent, was thriving? And I think I saw on the record that your client even admitted that his wife seemed to be doing better with Ms. Finkel present as the guardian of the person.
That doesn't mean that he did anything wrong, or that that Sharon was receiving inadequate care, or that my client was otherwise unfit or had breached his fiduciary duty, and those are the standards. The petitioner.
So was he? So is it your contention that he was not allowed to bring out these various factors during the hearing?
That is correct.
And
So-
how was he specifically? How was he precluded from doing so?
Well, in the record, and it's clear in the record, and I'll just cite just a couple of examples, but they're laid out in my brief as well, that first, the judge had made it clear that she had made up her mind before she had heard any evidence, which made it challenging to proceed. However, when I, who represented the appellant below, was cross-examining Nancy Niederlander, she limited my cross-examination. That's in the record at 733. She limited my cross-examination of my own client, who Mr. Santoro called on direct, and that's in the record at 1073. And shortly thereafter, at 1080 and 1081 in the record, she didn't let appellant call witnesses or present evidence, which it is clear in 8111 that he had the right to do.
So what additional evidence or testimony would have been elicited?
Well, Raymond Schrag was waiting outside to testify, leaving aside that there probably wasn't jurisdiction because he was not noticed in the proceeding, and I believe that is in 8129, that if you are going to revoke a power of attorney properly executed under 5-1501 of the General Obligations Law, that the agent under the power of attorney needed to be noticed. There were two agents here. It was not just my client. It was Sharon's attorney, Raymond Schrag. And there was no evidence that he was unfit or breached his fiduciary duty. As he was waiting to testify, he was subpoenaed by both parties, and he wasn't allowed to testify. I certainly can't speak to what he would have said because it's not in the record. But I believe that what he would have said is that her documents were properly executed and that there was no issue with incapacity at the time that she executed them. The second component of that is whether Peter had breached his fiduciary duty. And let's look at that. The plan that he had in place, she had 24/7 care. He was always there. Sharon was never alone. The housekeeper was there. He had an aide 5 days a week, 6 hours a day. Fern Finkel built on that plan. She added a nighttime and weekend aides, but she kept the doctors in place. She kept Melissa, the aide, in place. She added additional frequency of therapies, but there's also no evidence that what Peter gave Sharon at that time, before the hospitalization, before the guardianship was brought, was inadequate to meet her needs at that time.
Counsel, so right now, according to the record, Paul Medeiros is the guardian of the person and property?
That's correct.
So your position is, understanding is that there shouldn't be a guardian at all at this point.
That is correct, and I'm sorry that my time is up at the, that Fern Finkel was nominated, and once the court decided all the way at the end of the proceeding that she wasn't going to pay the amount that we had all agreed was fine, it moved the goalpost. I mean, in a way, it kind of switched what we had already agreed to. And because she was nominated, it undid the whole thing. We didn't agree to a guardian. We agreed to Fern Finkel. On the property management side, the analysis is somewhat different, and it's laid out in Article 81. And at this point,
you can reply. You can continue on your rebuttal. Thank you.
thank you very much.
You may proceed.
Thank you, Your Honor. My name is Frank Santoro of Farrell Fritz PC, and I represent the petitioners, respondents in this proceeding, Lauren Burston Gordon and Nancy Niederlander Gordon. The Court of Appeals and this court has held that the primary concern in any guardianship proceeding is the best interests of the alleged incapacitated person. And in the
Counsel,
same case,
but counsel, my question is that Supreme Court appointed Mr. Medeiros as the guardian of the person and property. How do you explain to me then how that happened without having the cross petitioner, Mr. Green himself, testify to respond to the basis, or at least respond to the allegations that were lodged against him that he wasn't taking care of her? How do we get there?
well, I believe that he was given the opportunity to testify and to cross-examine the witnesses that were offered.
Yeah, but he wanted to put on his case, right? Unless I'm missing something, he wasn't permitted to put on his case.
I think that in the process of the hearing, Mr. Green was afforded the opportunity to testify as to his fitness to serve in a fiduciary capacity, in fact, over objection
But
of the
Counselor,
petitioners.
Counselor, there's a cross petition here, correct?
There is.
So wasn't Mr. Green entitled to put on evidence to show that the alternatives to a guardianship were adequate?
I believe that he attempted to do so in the context of the proceeding, and the court determined.
You mean when he was called on your case, he testified and that's sufficient for him to sort of dispute the allegations raised? Is that
He was-
your position?
I'm sorry. He was essentially given the opportunity to elicit direct on the evidence of his fitness to serve in a fiduciary capacity. I think when we come down to the sufficiency and reliability of the alternative mechanisms or the dispositional alternatives to a guardianship, the issue was whether these advanced directives, the power of attorney, the healthcare proxy, and the trusts, were sufficient to provide for Sharon Green's personal needs and property management. And I think what the respondent here, or the appellant here, attempted to do was to say, hey, we have to get to the issue of the validity of these instruments before we determine whether they are in fact working to protect Sharon Green as an alternative to guardianship. And I think that the trial court, with the wide latitude of discretion that's given in this kind of proceeding, it's an abuse of discretion standard, determined based on the record that indeed the power of attorney, the healthcare proxy, and the trust that had been in existence since 2015 were simply insufficient to provide for Sharon Green.
So no issue with respect to the validity of the documents, correct?
Well, we didn't get to that issue because it wasn't necessary to get there. I think we heard that Peter Schrag would have testified that these documents were squeaky clean and that they were executed under circumstances that eliminate all doubt as to whether they really represent Sharon Green's intent as to who should handle her affairs. But whether they did or didn't, the trial court was satisfied that they were not going to work to protect Sharon Green because Peter Green had demonstrated through his conduct, through his de facto exercise of fiduciary control over Sharon Green's person and Sharon Green's property, that a guardianship was necessary. He didn't do that which was necessary to protect.
Counsel, then how do you respond to the appellant's counsel's argument before, saying that before Ms. Finkel didn't change any of the care for Mrs. Green. All she did was she built on what was already in place. So how do you explain that? I mean,
I think we have to look at the record. Before Fern Finkel took over, Peter Green was spending approximately $50,000 per year on Sharon Green's care. There was an aide 5 days a week, 3 to 5 hours a day. After Fern Finkel took over, there was 24-hour, 7-day-a-week care, and the care, in order to provide Sharon Green with the dignity and care that she deserved, is in excess of $550,000 a year. He was spending money on businesses, developing businesses with Sharon's money rather than providing for Sharon's care. And the motives of my clients have been attacked in the proceeding, but when you look at the cross-examination, and when you look at the evidence of Peter Green's conduct in acting in a de facto fiduciary capacity that's in the record, you see that the care was not sufficient. It was more than just building on a plan. There was no plan. Peter Green is a man in his 80s, and he just was not up for the job. There was no plan in place before Fern Finkel took over.
Well, isn't that the issue, though, counsel? If, in fact, the allegation is that he breached his fiduciary duty, so should he not have had an opportunity to present witnesses and present testimony to refute that claim?
Well, I think he himself testified, and his admissions were such that it was conclusive that he indeed breached his fiduciary obligations.
Well, can that determination actually be made until all of the evidence and all the testimony has in fact been elicited? I mean, if he wants to elicit additional testimony, why should he not have been allowed to do so?
I think the trial court has a certain amount of discretion in terms of how long this hearing is going to go, how many witnesses we are going to have when it comes to the evidence in the record establishing, for example, the neutral court evaluator couldn't have been any clearer as to the deficiency in care and the necessity of a personal needs guardian. And the temporary property of the guardian, temporary guardian of the property was clear as to the lack of any kind of real financial oversight and the conflicts that exist.
And one last thing, counsel, before your time is up. Your clients have no issue with Ms. Finkel continuing as the guardian of the person, is that correct?
We do not, Your Honor.
Thank you.
Thank you.
May I proceed?
Yes, you have 2 minutes in rebuttal.
Thank you, Your Honor. I want to touch on a couple of points. Number one, a judge has a discretion to control her courtroom. She does not have the discretion to depart from the clear language of legislation, and that is outside the scope of a judicial responsibility. The legislation is clear. It does not equivocate. He had the right to call evidence, to produce evidence and call witnesses. He did not.
Counsel, I want to go back. I mean, the issues that I think concern this bench are less the money and more the person at this point. So my question to you is what my colleague asked your adversary. What's your position with respect to Ms. Finkel going forward?
I would go back to what we did in the beginning, which should have been left in place. I'm not backing away
Are
from
you
that.
saying that whatever your client did was sufficient and nothing more was needed? Or are you willing to continue with the plan that Ms. Finkel implemented?
I'm saying both. So I want to just quickly respond to that. My client would agree to Fern Finkel because that's what we had agreed to do. I am not conceding that Mr. Green did anything wrong with respect to her personal needs care prior to the guardianship, because there is no evidence that the care that he provided was inadequate or otherwise was inadequate to meet her needs, or that it otherwise caused her hospitalization. She's a very sick woman. That's not disputed. She has multiple sclerosis. She has depression. She's the only child of 2 Holocaust survivors. No one can save her. There's no question about that.
So are you saying, counsel, and let me get this, so I'm clear, you're saying that you're okay, that the sense I get is Fern Finkel was nominated by the parties, it's fine, but that's it, you're not relinquishing your fight, or not fight, but your dispute as to whether or not guardianship should be put in at all, period.
Right, and to clarify that, but his nomination of Fern on the personal needs side was not a concession that he did anything wrong sufficient to
Right.
warrant revocation of the power of attorney on the property side. And the petitioners, as they were constrained to do, tried to meld the two. But I asked this court to look at where is the evidence and where was the process. They haven't cited to any specific evidence that he breached his fiduciary duty, and he certainly did not concede it.
Thank you very much, Counselor.
Thank you, Your
So-
Honor. Thank you, Your Honors.
Thank you. Interesting case. Okay, then the next case is People versus Sabelos. Petitioner, appellant. Okay, you can proceed.
Thank you. May it please the court, for Mr. Cevallos, the Law Office of Epstein and Conroy by Jason Eldridge, E-L-D-R-I-D-G-E. If it pleases the court, I would like to just address my remarks today to the first part in our brief regarding the settlement conference, since the rest of our arguments hang heavily upon that point. Our argument is that the court erred when it altered the transcript. Just at the outset, I'd like to say I think it's easy to look at this transcript and conclude that the court reporter simply made a mistake, but I have 4 simple points I'd ask the court to keep in mind today. The first one is the court reporter's statement about what happened. In the people's motion and affidavit to settle the transcript in this case, they reported that they spoke to the court reporter, who said that her notes did not indicate that she had made a mistake, but that it was possible. Of course, if it's possible she made a mistake, it's also possible that she didn't make a mistake. And when settling a transcript, a trial judge is directed to give great weight to the transcript prepared by the court reporter.
So, counsel, in this instance, the defendant was charged with multiple counts of criminal possession of a controlled substance. Is that correct?
That's correct, Your Honor.
And the issue is that the transcript states on multiple sections criminal possession of a weapon or weapons possession charges.
That's correct, Your Honor.
So is it likely that there would be so many references, if in fact the court clerk had made reference to possession of a weapon as opposed to possession of a controlled substance numerous times, is it likely that neither the court, the assistant district attorney, or the defense attorney, or the court clerk would not have corrected what was being stated? The allegation is, or actually the transcript initially reflected, that the court clerk made these statements while he or she was actually taking the verdict, meaning he or she was actually reading the charges from the verdict sheet. So again, is it conceivable that no one would have picked up on the clerk making these statements, these erroneous statements, and made a correction? Or that the court clerk herself or himself, in reading from the verdict sheet, would have read or would have stated criminal possession of a weapon when the verdict sheet clearly stated criminal possession of a controlled substance? And let me add, not only the judge never said anything, the assistant district attorney never said anything, the defense attorney never said anything, and when the jurors were being polled, apparently none of them said anything. So no one makes a correction when it's so blatant and so obvious? Long question, I apologize.
I take the court's point. It's a good point, but I have two responses to it. The first one is regarding, I think, the lack of consistency in, I'll call them misstatements at this point, whether they were made by the court clerk or whether they were a transcription error. The transcript does not read that the word possession of a controlled substance was simply replaced in every incident with weapon. It's inconsistent. For instance, as the transcript reads, when asking the jury foreperson for the verdict, the transcript reads weapon in the first degree and weapon in the second degree. Then when addressing the jury as a whole, saying, is this your verdict, the transcript reads controlled substance and weapon. And then going back to polling the jury and weapon again. So I think part of the explanation that the court clerk gave in her, again, she never submitted an affidavit. The people in their motion paper said they called her. She said, I may have made a mistake. And she indicated that she was using a macro or some sort of shortcut when she was doing these proceedings, meaning she hits one key and then it recovers a series of words.
We're all familiar with that.
I apologize.
Right. We all know how court reporters make transcripts, and there are errors in them.
And not only that, we also know that court reporters, after a while, they also have their own ways and their own shorthands, a way of transcribing, or at least during the actual taking of the testimony. But again, it goes back to my point. The verdict sheet specifically stated criminal possession of a weapon, or the opposite. It does not in any place on the verdict sheet does it say criminal possession of a weapon. So again, does it not make sense this is an error in transcription as opposed to what was actually stated during the course of the trial? Not to mention that there was never any testimony or evidence during the course of the trial concerning weapons. The use of weapons, the presence of weapons, or weapons having anything to do with the case. It was merely the transporting of narcotics.
To get back to Your Honor's first point, I take the point that the verdict sheet was correct, and that both attorneys addressed the correct charges. But again, I think to address maybe the second part of that remark, there was no testimony about weapons during trial, but there was significant testimony about violence and the potential for violence during this case. In the defendant's opening remarks, they mentioned Mexican cartels and their propensity or their potential for violence. Both parties called expert witnesses during this trial, and both expert witnesses testified about the history of cartels and their propensity for violence. The defendant himself testified at trial. His defense during the trial was twofold. Number one, he thought he was only transporting marijuana, and number two, he felt pressured into what he was doing because he was fearful of the cartel.
But aren't we going too far afield here? basically what was before the trial judge was to settle the transcript. And that happens, right? And the judge looks and sees, are there any errors in the trial transcript? And in this case, while it's true enough that the court reporter didn't come and testify, and that would have been nice had she done so, didn't the judge say, I am in part basing this on my own recollection of what I heard during the course of the trial, and why isn't that sufficient?
I think, Your Honor, I have 2 points to that. The first one being what the judge said was not that clear, that I am basing this on my recollection. He said something akin to, I would never have allowed something like this to happen. The second point to that is that there was sworn testimony at the settlement conference. It was from the defendant. I grant it, the defendant is considered an interested party, but the judge dismissed his testimony out of hand. The defendant testified as to where he was sitting, what he heard, why it may have been hard for other people to hear what was going on in the courtroom. And the judge, in his remarks, it's I think clear that he disliked the defendant, very quickly called the defense absurd twice, and then accused the defendant of perjuring himself at the settlement conference. When if
I
you
don't
look,
think that it's fair to say that the judge disliked the defendant. I don't know that I would characterize it as such, and I don't think that's fair comment. And I also don't believe that there's anything wrong with a judge saying, I would never, if I'm sitting there and I'm listening to the charges, I know what the charges are, I'm never going to not say something, especially where it occurred in the record, according to the transcription, multiple times.
I think the difference here being, Your Honor, is that there was no affidavit or testimony from the court reporter. There was testimony from the defendant. There was, as I said earlier, inconsistencies in the error, so that if a MAC were being used, you would expect it to be in other places in the transcript. I see my time is up.
Thank you.
Good afternoon, and may it please the court. Michael Yetter for the people. On the
So why wasn't the court reporter called to testify? I mean, wouldn't that have made sense in the context of this case?
Well, respectfully, Your Honor, we made the decision not to call the court reporter. It's our position that her testimony largely would have gone to explaining the possible error that happened, as we reported in, or as I reported in my affirmation. The court reporter.
If that's all she could say, of what probative value is it? If she could say maybe it's a mistake, maybe it's not. I mean, let's leave out the hearsay nature of it. If that's all she was going to say, then why would that rule the day on what was actually, or what actually transpired for the record in the courtroom at the appropriate time?
It wouldn't, Your Honor, and that's why our position is that the judge's recollection should control. He's the final arbiter of the record. And then when you look at the actual record, as some of the questioning bore out, I mean, you need to look at the indictment, the parties' opening and closing statements, the jury charge, the verdict sheet, which the judge said at the hearing the court clerk would always be reading from. And that's why, because of all of that evidence, it led the judge to conclude that it would have been absurd for the court clerk to say weapon instead of controlled substance 5 out of the 6 times she was referencing those charges, and no one said anything whatsoever about it. And so for those reasons, we think it's pretty unequivocally clear that the judge reached the right decision as he was required to do.
Well, even if it was equivocal, the judge was required to make a decision about what the record said, and that controls, right?
That's correct. I mean, that's Bethune is the most recent case on that, Alomar, and then going back to the early 1900s in the Bukafuri case we cite in our brief. I mean, it's always been the case that the judge's recollection controls the judge's notes, and those are what are to be considered. And even though a certified transcript is entitled to, quote, great weight, the judge's recollection, quote, must prevail. And so that's the situation we're at with respect to the hearing in this case. And I think when you consider the defendant's alternative arguments, it's really not persuasive. I mean, the idea that there was some outburst in the courtroom during the rendering of the verdict, which was the argument they raised. I mean, Justice Mandelbaum said, I would never let that happen. And if it did happen, some prosecutors would be held in contempt for doing and engaging in that type of conduct. And that's where I think the earlier reference to never allowing something to happen on page 17 of the settlement transcript I think that's what defense counsel was just referencing. But really, as the settlement conference, again, the totality of the evidence, the judge's recollection, it all bears that this was a transcription error in this case. Unless there are any further questions, I'd ask the court to affirm.
Thank you. Rebuttal?
If the court has no questions, I think I've made my point clear. Thank you.
Thank you. Thank you both. The next case is Santos versus Townsend.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff appellant. I only have 3 minutes. I'm not going to go over my time. I think the issue is a simple issue here. The question is whether or not an order secured by one party, which results in an order of preclusion and dismissal against that party, would apply to other parties who didn't participate.
Well, you know, counsel, maybe not, but in that prior order that we're talking about, there was the 2013 action was dismissed. There was no re-argument motion or an appeal of that. So how does that not, in a sense, your argument has been, it's gone, right?
Well, first, I don't think so. I think if you, Your Honor, if you look at the order, at least as I read it, it's on 255 of the record, obviously, you know that. It looks to me when it says papers numbered, I don't think that's an appealable order. Obviously, you can't appeal an order that's granted on default. But I still think the issue is whether
That's why you moved to vacate then, right?
You could, but I think the legal question is what is the effect of that order? If you look at Zletz, if you look at your decision in Simon, if you look at the Second Department's decision in Wang, there are factual differences in those cases, but it seems that the courts have held that an order that is granted vis-a-vis one party doesn't apply to another party where that party doesn't join the motion or take some affirmative action. And that's our argument. Now, my adversary brought something up, which is, it's smart. She said, well, why would that order go in on default? There are a myriad of answers we don't know from the record. It's possible that the plaintiff's counsel lost touch with the plaintiff and then the plaintiff got back, or it's also possible that the defendant who got dismissed from the case, Laura Rivera, we're not really sure who that is, but it's not a property owner. Maybe there was no viable case against her.
But the plaintiff in this action is represented by the same firm on both actions, though.
Yes, 100%. But there are occasions that lawyers will bring second actions after a first action was dismissed where that first action was not a merit-based determination. Certainly under Strang and under Maitland, you can't avoid an order of preclusion by bringing a second action, but you can bring a second action when there's a dismissal based on a 3126 dismissal for failure to comply with discovery. But here I think the legal issue is...
No, but there's a question here. In that prior action, the dismissal was based because the court precluded the plaintiff from testifying at trial. Is that correct?
The conditional, or yes, there's a conditional order
Right.
on 248 to 249.
Now, how does that not benefit the other defendants? Because if he's not able to testify at trial, it doesn't matter which defendant is moving to dismiss. I mean, he can't testify at trial. He's not going to be able to prove his prima facie case, so every defendant is going to get the benefit of that.
Well, I'm not, again, I think my position is a little different. I understand what the order says, but when you read the order totally, every single order I'm sorry, Judge Giss, may I finish?
You may.
Okay. Every single order refers to the motion being of Laura Rivera, and where it says the complaint is dismissed, the court can say the complaint is dismissed, but dismissed as to whom? Is it dismissed as to everyone, or is it dismissed as to the move-in? We think the cases say it should be just dismissed as to the move-in. Thank you.
Thank you. You can proceed, Counselor.
Thank you, Your Honor. Jessica Erickson, Haddam, Farragut, Prendergast, and Merlino for the defendant respondents in this case. The plaintiff's position concerning that the prior decision of Justice Stinson does not apply to all of the defendants in this case is mistaken for two simple facts. One, the order specifically states, as Your Honor pointed out, that the plaintiff was precluded from testifying overall at trial, and if he's unable to testify at trial, he will therefore be unable to make out his prima facie case against any of the defendants. Secondly, the case was marked disposed in its entirety by that order of Justice
Nothing
Stinson.
happened after the case was dismissed. It wasn't like the case went forward against other defendants.
Well, they brought a second action, Your Honor. Well,
No, leaving the second action aside, right, that we're dealing with the issue of whether it was dismissed as to all defendants. Right.
Right,
It got
nothing
dismissed.
happened after
Nothing
that
happened.
decision,
The judge
correct.
didn't say, I'm dismissing it as to defendant one, and we'll set a conference as against defendant two. It was
That's correct. And
dismissed.
actually, how this issue came up, and counsel for the defendants in this matter discovered this, was plaintiff's counsel erroneously filed a motion under the prior index order, and there was a decision in that motion that said this case has previously been dismissed, and then he didn't make a determination on that motion.
You're saying it was by chance that he figured out there was a prior action that was dismissed, huh?
Correct, Your Honor. It wasn't disclosed by plaintiff's counsel until after all of this was discovered. If there are no further questions, thank you, Your Honors.
Thank you. All right, rebuttal.
Judge Long, just very simply, I think that this is the law that I would like you to apply. It's from, I'm sorry, I can't see, Wang against Lin, it's in our brief, 94 AD 3D 850.
What's the site?
94 AD 3D 850 at 852. Last paragraph of the opinion. The Supreme Court erred in granting those branches of the motion which were to strike the complaint insofar as asserted against the three remaining defendants. And here's the part I just, because I think it deals with your issue. Although these defendants were similarly affected by the plaintiff's actions, the record contains no evidence that they ever sought orders, either compelling disclosure or striking the complaint. Thus, the Supreme Court should not have stricken the complaint insofar as asserted, and then they go over the
Well,
defendants.
that's very different. Striking a complaint is very different from precluding a plaintiff from testifying so that the plaintiff could even put on a prima facie case. That's apples and oranges. Striking a complaint is very different.
I don't disagree, and
Okay, all right. I just want, okay.
yeah, I'm just
Got it.
talking about the effect of the order.
Okay.
Thank you for listening to me.
Thank you. All right, the next case for argument is Valdez versus the City of New York. You may proceed, Counselor.
Good afternoon, and may it please the court. My name is Jackie Pena on behalf of these defendants' appellants. Here, the overarching point that frames the defendant's position is that there are serious issues of material fact that preclude summary judgment from the plaintiff. There are two main questions and issues of fact, and the first one is that there's an issue of fact as to whether or not plaintiff needed any other safety device at all to perform his job on the day of the accident. This very issue of fact creates a question as to whether the protections under the labor law are even applicable to this case. Here, the undisputed facts are that plaintiff was working on a pipe scaffold on the day of the accident, that he is 5 foot 6 inches, and that he also testified that he was able to reach the planks of the scaffold above him on the day of the accident. As such, for the plaintiff to perform his job, he did not need any other safety.
Sorry,
Device.
he was able? I thought it was that he was not able to reach above, and that's why he had to use the milk crate.
Well, that's the issue of fact, Your Honor, is whether or not our contention is that he was able to reach the pointing that he needed to perform the day of the accident, and that's further evidenced by some of the testimony in the case. One of the affidavits, for example, from Mr. Santos Mayorkin, which plaintiff submitted with his motion for summary judgment, indicated that Mr. Mayorkin was with the plaintiff for about an hour before the accident happened, and that he was just feet away from him, and he did not see plaintiff using the milk crate on the date of the accident.
But that's different from him not being able to reach at a certain level when he's doing the pointing, which Mr. Mayorkin also testified that quite often they were not able to reach, and they also used the milk crate in order to be able to reach a certain point in the wall.
So that is the second issue, Your Honor, is whether or not he was actually on the milk crate at the time of the accident. And that is a very specific issue that is important and vital in this case, is whether or not he was actually on the milk crate on the day
I
of
must
this
be missing
accident.
something, but we're not disputing that the plaintiff fell, right? I mean, that much is certain, correct? He did sustain a fall.
The issue, well, that is a question, Your Honor, and
You mean he
that
didn't
goes
fall?
To that goes to the second point as to whether or not there was actually an accident because of the credibility issues here with the plaintiff.
Well, you
but you know-
summary judgment to a plaintiff, even if there's no other eyewitness to the accident. I mean, we've held that a million times. He said he fell, and he described how he fell. And just simply saying, oh, we don't believe him, isn't enough to deny him summary judgment.
The evidence in the case shows that perhaps he was not on the milk crate, and that is the vital issue here as to whether or not there are protections afforded.
What evidence shows he wasn't on the milk crate?
The evidence from Mr. Mayorkin, which is the affidavit submitted in support of the motion for summary
Because
judgment.
Mr. Mayorkin said he didn't, he said that they routinely use milk crates to stand on them. He said that but he did not say that there's nothing, he said he couldn't see from his vantage point.
If I may quote exactly from the...
Mayorkin he could not see plaintiff stand on it or fall, he did not see plaintiff stand on it or fall on the crate that day.
Yes. So he did in the affidavit, it does say that there was a milk crate right next to Adon, but I did not see him stand on it or fall from the milk crate that day. And that is the
Okay.
precise issue as to
He
whether or
didn't witness
not...
the accident.
He witnessed a fall, but not a fall that is necessarily protected under the labor law. The lower court found that that there was an elevation hazard here by him stepping on the milk crate and was using the milk crate as a ladder in this case. And
But we have cases, Ferguson, I think, is one, where the plaintiff stood on a bucket. So there are cases where, because of the lack of proper devices, improper devices, if you want to use that term, a bucket, or in this case, a milk crate, are used. So why is this not the same as Ferguson?
It is not the same because there's an issue of fact as to whether the plaintiff was actually using the milk crate. It was on top of the milk crate at the time of the incident. And that is highlighted by the fact that Mr. Mayorkin's affidavit...
How would he be on top of the milk crate if he's falling? Are you saying that when he lands, he has to have landed on the milk crate?
No, Your Honor. What I'm saying is that there is no evidence that at the time that the incident happened, that he was actually standing on top of the milk crate to perform his job to reach and access the wall.
Other
in the
than
area
his
where he needed to.
testimony.
And the testimony of another witness, Carlos Tuapanta, who says he saw him standing on the milk crate and then saw him on the ground after he fell, and the milk crate.
That's another disconnect, Your Honor, because that witness was actually a floor above. And so he said that he saw him standing on the milk crate at a different time, not at the time of the incident. And that is the question here, is whether or not he was on top of the milk crate at the time of the incident, which could arguably make it an elevation-related accident. Here, he could have fallen for some other reason while he was standing, and that would not be covered under the labor law.
Okay. You'll have time in rebuttal. Thank you.
Thank you, Your Honor.
You can proceed.
Good afternoon, everyone. My name is Stephen Weinstein. I'm with the Weinstein Law Group, and I represent the Don Valdez, the respondent in this matter. I'm here to urge you to affirm the order of the lower court, which granted summary judgment on the Labor Law 240 cause of action. Mr. Valdez was a Local 1 bricklayer who was assigned to do pointing work at the school. He clearly testified in his deposition that he could not reach the top of the column that he was doing pointing to, and he needed an elevating device. No device was provided to him. On the day of the accident, he was facing two elevation risks. One was having to be up the scaffold, which they provided him a scaffold, and the second one is once he's up there, he needs to get up higher to put the mortar in between the bricks. So although they gave him a scaffold to get up there to the fourth level, they didn't give him any type of device to get up there to put the mortar into the bricks. So he availed himself of the thing that was there, and that was the milk crate.
But I believe the testimony was no one ever told him, excuse me, to use the milk crate. He was
That's
never
correct.
told to use the milk crate. And also, I believe there was testimony that there were ladders that were available and that he never asked to use a ladder.
That's correct. He elected on his own to use the milk crate. The defendants did not furnish to him any type of an elevating device. Although there's testimony that there were ladders on site, there is no testimony, no evidence at all in this case that he was instructed to use it, that it was readily available, and that had he used it, he would not have gotten hurt. And that's what's
Counsel, and to take your point, actually, even if he used the ladder and fell off the ladder, that would still be a violation because it wasn't sufficient to protect him from falling. I mean, he did fall, right? I mean, I can't.
I would
there's
agree.
no dispute he took a fall.
I would agree with you. I would say to you that even if he had a ladder, it's not safe because if you're up there doing mortar work, you can't maintain a
The
three-point
bicycle that
contact
wasn't.
on the ladder.
It's the bicycle that wasn't working.
That's correct.
But
That
there
was
was
the right
nothing in the
device.
record, counsel, that I saw that stated why the bicycle was not working.
Because what they did was they overlapped the planks from one section to another. So the section of the scaffold that's right by the building, that could go up and down so that the worker can get up a little bit or a little bit further down. So what they did was the planks overlapped each other from one section to the other. So it's not possible. They'd have to take out all the planks, the whole line of the scaffold for one section to be raised so he could do his job. And Carlos Toapanta and Santos Mayorkin both said that in their affidavits.
Yes.
So in this situation, the appellants have argued that there's not a significant elevation differential. I would most respectfully disagree. The case that was relied on by the lower court, Mutadir, was a case where a guy fell off a milk crate, and this court found that that was an appropriate elevation differential.
No, but she's arguing that there are credibility issues as to how this accident happened, or
Those, with all due
manner
respect,
of
Your
how
Honor,
it
those
happened.
credibility issues are not bona fide or material issues of fact. Whether or not he drank the water while he was conscious or not, whether or not the mortar was behind him or to his side, none of that goes to the issue of whether there was really a 240 violation, whether or not there's a question of fact with respect to that. That's all side stuff. Any other questions? I see my time is up.
Thank you.
Thank you.
May I have rebuttal?
Thank you. Just to further expand, as to the bona fide issues of fact or credibility issues, whether or not the plaintiff was actually on the milk crate at the time of the accident is an important issue, a material issue of fact here, and whether any type of elevating device was necessary is also an issue of fact. Our contention is that there was no need for any other safety equipment here. The plaintiff had the ability to reach his work area without the assistance of a safety device. There was no need for a ladder. There was no need for the
I know you keep
bicycle.
saying that, but where was that in the record that other than his testimony that he couldn't reach where he had to do the pointing work, who said he could?
Well, the plaintiff testified that he is 5'6", and we have testimony from Mr. Egan, who was a project officer, who testified that the area between the top plank and the bottom plank was about 5'8". And in addition, the plaintiff testified that he was able to reach the plank right above him. And so that leads to the conclusion that if he was pointing at the wall in front of him, all he had to do was just reach his arm forward and maybe a little higher. He did not need an elevation device to lift him up because of his height and because of the area that he was working in. And Mr. Egan's testimony as to the height of the area being about 5'8" is actually the only evidence we have in the record of the brick area where the plaintiff was working.
But that contradicts the testimony not only of the plaintiff, but also of the witnesses who all testified that they needed, at times, to use the milk crate because they could not reach the point where they needed to work.
Right, and that is, again, Your Honor, the distinction is that at times, right? There was also testimony that Mr. Mayorkin, who was a couple of feet away from him, was at a different level than the plaintiff at the time of the accident as well. And so that is the precise issue, is at the time of the incident. That is what we're dealing with here, not the day prior or the day after at any other time.
Okay, thank you.
Thank you, Your Honor.
The next case is People versus Charity Finch. You may proceed.
Delorny Namoran on behalf of Charity Finch. Your Honors, Ms. Finch was a 19-year-old single mother suffering from anxiety and depression at the time she committed this unfortunate offense. Despite this offense having a weapon, Your Honor, she was released pending the case for 3 years in the community with no further offense.
So Ms. Finch pled guilty on January 11, 2018, is that correct?
Yes,
And so she was sentenced to, how many years probation?
3, Your Honor.
3 years probation. So if my math is correct, would she not have completed her probation in about 3 months?
Yes, Your Honors.
And so why is there an issue? You want to reduce her probation to 2 years so that what you're asking for, in essence, is that her probation, the probationary period, be reduced really 3 months. Is that correct?
At this point, Your Honor, yes, only 3 months.
Counsel, did your client also get a certificate of relief from disabilities?
Yes, Your Honor. At the time of sentencing, they did grant her a certificate of relief of disability, which comes with the presumption that she had been rehabilitated.
Yeah.
Yes.
So, okay, I got it. Thank you.
At this point, how often does she have to report to probation?
Your Honor, I can't answer that
You
question.
don't have that information.
No.
Okay.
But counsel, you, in your brief, I noticed you made reference to the Certificate of Relief from Civil Disabilities, and you stated that this showed how the court acknowledged the fact that, she had been rehabilitated or was almost rehabilitated or something of that nature. A Certificate of Relief from Civil Disabilities is something that is not uncommon, and that it does not necessarily show any determination as to rehabilitation. It just gives the probationer an opportunity to apply for certain jobs, to receive certain benefits as well.
Your Honor, despite it not being uncommon, it does indicate that they had acknowledged, or the court and the prosecution had acknowledged that Ms. Finch wasn't a danger to the community, given the fact that she had been out into the community with no further offense. This is only Mrs. Finch's, she has a very minimal criminal background. She has one disorderly conduct and a prior misdemeanor. She had no other violent offenses of this nature. And despite it not being uncommon, it is given in special occasion. It is given for a reason and an indication of positive behavior in the community.
So this was a negotiated plea, is that correct? She pled guilty to the assault in the third degree, the A misdemeanor?
Yes, Your Honor, she did plead guilty to.
And there's a valid waiver?
Your Honor, as to my second point, the waiver is invalid in this case. I'd like to spend some time discussing why this waiver is invalid. The Court of Appeals in People v. Thomas talks about the totality of circumstances when assessing an appeal waiver. It does not succeed solely on a single factor. Here in this case, not only is Ms. Finch's minimal experience in the criminal court system, plus her only prior offense is a disorderly conduct and one prior misdemeanor. We're not aware of any of her prior experience with appeal waivers, which commonly come with felonies in these cases. Also, what is really important, Your Honor, is that the court failed to explain to Ms. Finch the right to appeal was separate and distinct from rights that are automatically forfeited upon a guilty plea. The court states the DA's office, as a separate condition, requests and requires, in order to make this offer, that you agree to waive your right to take an appeal. Your Honor, I do believe that this statement, requests and requires that you take this appeal waiver, is confusing, Your Honor. I also understand that Ms. Fitch does sign the written waiver and her attorney is present when she signs the written waiver. However, again, in People v. Thomas, which is the most recent case about appeal waivers from the Court of Appeals, they overturned 2 of the appeal waivers, and the defendant had signed the appeal waiver, and her attorney were next to them.
Interesting you mentioned Thomas, because under People v. Thomas, is this waiver, my reading of People v. Thomas and my reading of this waiver, it appears to me that this waiver is valid under People v. Thomas.
Well, Your Honor, People v. Thomas does talk about that. It's not, Your Honor, I do not believe this waiver would be valid under People v. Thomas. I do understand that the written waiver in People v. Thomas that they overturned were egregious. And this is not identical to the written waiver in this case. However, People v. Thomas does not stand for the proposition that if the written waiver is written well, then the oral colloquy and other factors are not important. I see that my time is up. I'll answer any further questions.
Thank you. You may proceed.
Thank you. Good afternoon, and may it please the court. I'm Morgan Namian for the Bronx District Attorney's Office. The defendant in this case validly waived her right to appeal. And regardless, her sentence of 3 years probation was entirely fair, given the fact that she brandished a sharp knife, stated, "I'm going to jail," and then threw it at her neighbor, causing a deep bleeding laceration that required hospital treatment. The defendant knew that jail time was a possibility in this case. Nevertheless, she herself negotiated a sentence of only 3 years probation, which, as Your Honor noted, expires this coming January. Thus, her negotiated sentence of 3 years probation was entirely fair, given that she was initially charged with attempted first-degree assault and could have faced up to 15 years in prison for that charge.
So she was out for a period of 2 years between the arrest, arraignment, and the plea?
Yes, that's correct, Your Honor.
And
it was not 3
during that
years.
2-year period of time, she led a law-abiding life. Is that correct?
Yes, that's correct, Your Honor.
So does that not show that perhaps reducing it from 3 years probation to 2 years probation, and again, we're talking about 3 months, would not be, that may be proper?
Your Honor, to the extent that defendant spent time at liberty between her arrest and her plea without any police or other criminal history involvement, that not only was properly before the plea and sentence court at the time of the plea, but also this indicates that the defendant in this case had over 2 years or about 2 years to consider the plea, her charges in this case, and to discuss those things with her attorney who represented her throughout the pendency of that case.
And what's the people's position as to the waiver and whether it comports with People v. Thomas?
Your Honor, our position is that the waiver was valid under Thomas. The court specified that the DA's office, not the court itself, was requiring that the defendant waive her right to appeal as a separate condition. Furthermore, the defendant agreed that she discussed specifically the appeal waiver with her attorney. She said she was satisfied with her attorney, and she stated that she understood she was giving up the right to challenge the length of her sentence specifically. Furthermore, defense counsel stated at the beginning of the plea or before the plea proceeding, or at the beginning of the plea proceeding, sorry, that the attorney had discussed the appeal waiver with defendant in this case. And furthermore, at the end of sentencing, the court signed an order appointing appellate counsel, which just goes to the fact that if there was even any ambiguity that any appellate rights remained despite the waiver, this was a good indication from the court that that was the case. Furthermore, to the extent that it's important to note that there was a written waiver in this case, which, if there was any ambiguity in the court's language, the waiver emphasized the separate and distinct nature of the right to appeal, and also specified that the defendant retained certain appellate rights. Specifically, the waiver says that defendant would be waiving her right to challenge the length of her sentence. However, she would not be waiving the right to challenge the legality of the sentence. And again, defendant signed the written waiver on the record, stated that she discussed the waiver with her attorney and had no further questions. As to the sentence, the excessiveness of the sentence, I'd just like to point out again that defendant knew that the jail was a possibility in this case. She said it herself when she threw the knife at her neighbor. She was able to successfully negotiate down to 3 years of probation. And to the extent that my adversary argues that the conditions of probation are too difficult to maintain, first, there's no indication at all that defendant has had a hard time complying with the conditions of probation. Furthermore, any perceived difficulties are merely hypothetical at this point. Finally, I would just like to point out that my adversary did note that there were 3 years between the crime in this case and her plea, but that was only 2 years. I see that my time is out. Thank you.
Thank you. You may proceed with the rebuttal.
Yes, Your Honor. In regards to the court's colloquy stated that the appeal waiver bars challenges to the length of your sentence. And generally, and it's a short pronouncement, but I think that is important, and they talk about this in Thomas, when we have a defendant who is like inexperienced with the criminal court system to make such a general statement, the defendant can interpret that does come to the legality of
Isn't this why we have a defense attorney who, isn't this why we have a defense attorney who is standing next to the defendant during the proceedings?
Your Honor, it is important, yes, they do have a defense attorney, but the court's colloquy must ensure that the defendant has a full appreciation, that's what Lopez and Thomas continue to say, of the right that they are conceding at that time. So it is also not important.
Isn't one of the questions that they discussed the waiver of appeal with counsel?
Your Honor, that question alone is not sufficient alone. We have seen courts overturn appeal waivers with defendants having an attorney next to them and stating that they were satisfied with the representation of their attorney. That is a case, that is one of the examples in People v. Thomas. So that alone is not sufficient, and I think People v. Thomas is talking about the totality of circumstance for that reason, not identifying that an attorney alone can cure any confusion, any ambiguity, because it is on the court's colloquy to ensure that defendant has a full appreciation of the right that they are conceding. And the colloquy here, I do not believe that Ms. Finch had a full appreciation of the right that she was conceding because of the numerous shorthand pronouncements that can be confusing. If you tell a defendant that you are barred from challenging a length of a sentence, and then there's a written waiver that talks about legality, it seems more like a contradiction versus, us as attorneys understanding the difference. I see my time is up here.
Thank you. Thank you both. The next case for argument is Bankers Conseco versus KPMG. You may proceed, Counselor.
Thank you. May it please the court. I am Richard Epstein for the plaintiff's appellants. The complaint here alleges that defendant respondent KPMG substantially assisted in a scheme to fraudulently induce plaintiffs' appellants to enter into 2 reinsurance agreements with an entity called Beechwood. The complaint alleges that KPMG did so by devising the demand note scheme and providing a valuation letter that falsely supported 2 key elements of the fraud.
Can we talk about the valuation letter a little bit? As I understand the lower court looked at that valuation letter and said, who in their right mind would rely on this letter? It provided 0 information about valuation. What's wrong with that analysis? It was, especially for an outfit like your client that's so business savvy, right?
Your Honor, if that were the only piece of information that my client had ever gotten regarding the amount of capitalization in Beechwood, His Honor might have had a point. However, the court below completely ignored the allegations in the complaint that the plaintiff's appellants had received tons of documents and information from Beechwood purporting to show the $100 million capitalization. The valuation...
Well, it might have been just one piece, but it was pretty important. I mean, it was pretty, again, it was pretty important. So again, I do not understand how your clients, given their business savvy, could have, could have relied upon that.
Because there's a difference between information and confirmation. What we received in the valuation letter was confirmation. And as this court has previously held in the ID case and in other cases, when you receive a bunch of information, and we received it from March through September, and then you get a letter from a reputable independent entity that says, this confirms what you've been told, that is reasonable reliance. More importantly, as this court has indicated in the Lorelei case and in the Epiphany case, issues of what reliance is reasonable should not be decided on a 3211. That's something for trial. That's not something where we go and say we're going to make that factual determination. It is a factual determination here on a 3211. So here we have an underlying fraud, which is one of the 3 elements at issue. The underlying fraud is the fraudulent inducement based upon 2 key things: the $100 million capitalization and that the Beechwood was run, owned, and controlled by 2 upstanding insurance industry executives. As we've now come to know, they were instead a front for fraudsters at the hedge fund Platinum Partners, with whom no insurance company would have done business, and no state regulator in New York or Indiana would have actually ever approved such a deal. And in fact, there was no $100 million in capitalization. So the 2 issues here are actual knowledge and substantial assistance. So in actual knowledge, again, this court has made clear that we don't have to prove at a 3211 stage that KPMG has admitted actual knowledge. Rather, you only have to generally plead it, as this court said in the AIG case, and you look at it from the surrounding circumstances. Here we have 5 such surrounding circumstances. The first is that the complaint alleges that KPMG was hired to conceal Platinum's involvement, and the KPMG understood that insurance companies like the plaintiff's appellants would not knowingly do business with Platinum. And this is not an upon information and belief allegation. It's an allegation that is based upon an email from KPMG principal Michael Athanason that says that the purpose of the valuation is to prove to the insurance company that this is a substantive reinsurance company, even though the holding assets that are illiquid are hedge fund interests. Most importantly, that email says these are guys who own interest in Platinum Value Investors. They are worried that insurance companies don't want to deal with hedge fund guys. They don't want the insurance company to know the assets upon which the valuation is based. Second, The complaint alleges that KPMG knew of Platinum's control of Beechwood and that KPMG communicated directly with Platinum. Third, the complaint alleges that KPMG complied with Platinum's request to strip the identification of Platinum from KPMG's draft valuation letter, understanding that its purpose was to trick plaintiffs' appellants as to Platinum's control of Beechwood.
And what role, if any, do you allege that they had in connection with the idea that the capitalization of the investors should be by a demand note?
Well, we allege in the complaint that KPMG was the entity that devised that concept. We allege at paragraph 47 and 47 through 50 that Herschel Wien, a tax partner at KPMG, came up with the demand note scheme to have the Platinum people issue a demand note which would be collateralized by 3 Platinum assets. And that was a way to create a wall between Platinum, so that nobody could see that it was there, and the alleged $100 million in capitalization. So when I get to substantial assistance, let me just jump ahead for one quick moment. The 2 primary things there are devising the demand note scheme, and this court, for example, in Gansett 1, has held that when you devise part of the scheme, you are giving substantial assistance. 2, that they removed the Platinum names from the valuation letter. And 3, that they gave the valuation letter, which was relied on by my clients and by insurance regulators.
Thank you. You'll have time on rebuttal.
Good afternoon, Your Honors. I'm Lisa Wood of the law firm Foley Hoag here for KPMG, the respondent. And thank you for agreeing to hear this argument in person. I have not been in this courtroom before, and it's a privilege. I want to make 3 points in the brief time that I have. First, as a matter of law, plaintiffs cannot meet their burden under 3016B to allege that KPMG's professional services to Beechwood amounted to substantial assistance because their claim boils down to an omission case. And I'll talk about that more in a minute. And as a matter of law, if we don't have a duty to them, which they've now conceded on appeal, we had no duty to them, we had no contract, no fiduciary duty, no relationship, then if there's only an omission, which is complained about, there's no substantial assistance.
Well, did Beechwood have a duty?
Yes. And these parties...
Isn't that the duty that we're looking at when we're trying to figure out the underlying fraud, the fraud by omission?
That may be relevant to a claim against Beechwood, but in an aiding and abetting claim, in order to establish that KPMG provided substantial assistance, if all KPMG is faulted with doing, which here is failing to identify the assets being valued and failing to explain that the capital was based on a demand note structure, that isn't substantial assistance unless they had a duty to the plaintiffs.
It's not enough that Beechwood had a duty.
Correct.
Even if they assist them in a major way.
Right, and they didn't assist them in a major way.
That's
and that's
a different issue.
Correct, but I think the Court of Appeals decision against Seward Kissel, I always butcher the name of the plaintiff, it starts with a U, but it's a very important decision involving when professionals can be sued on an aiding abetting basis. In that case, the law firm, coincidentally, its client was a hedge fund. It wrote the PPM. It was aware that the hedge fund had prior problems with the SEC, both as an institution and individually, did not disclose that information in the PPM. But the limited partners, the investors who invested in the hedge fund, couldn't bring an aiding and abetting claim against Seward Kissel because it didn't have a duty to the limited partners. Now, that doesn't say that the limited partners wouldn't have a claim against the fund, and presumably they did, but we're here just talking about KPMG. And this case comes and was pleaded after a lot of litigation.
Did your client know that the demand note and the other letters were going to be used by their clients to get the investors to invest in their, I guess, to invest in them?
Well, they knew. I
That's
think
the
record is
allegation, that they
clear.
knew.
They knew that their summary valuation letter was going to be provided to the plaintiffs. They advised the client on tax and accounting issues with respect to the demand note structure, but they weren't involved.
That goes back to my colleague's point. That goes back to my colleague's point that the duty is between the plaintiff and and your client. Not your client, the other investors. That's where the duty goes, and that you guys were just there. But in this case here, those cases that you mentioned, that's where they didn't disclose something, right? And here, you guys actually did an affirmative act.
Well, we didn't do
At
an
least the
affirmative.
allegation is there. That
Right,
it was an
but the
affirmative act.
valuation, the fault of the valuation in this case is a failure to disclose the identity of the assets being valued. And it's clear on the face of the valuation letter that they're not identifying them. And this would be a very different case if KPMG lied and said, we are valuing 3 assets and here are their
but that
names.
demand note that you put together, the allegation is that you knew that the assets that were going to be backing up that demand note were worthless.
No, there is no allegation to that effect. And the valuations done here
I saw that.
were relied upon audited financial statements conducted by other firms.
Because I thought there was, unless maybe I read the wrong complaint, but there was also an allegation where your clients were being asked by their clients, how do we get these investors to sign on board? And this whole idea, this whole concept you guys came up with this concept, no?
The KPMG advised Beechwood for tax and financial reasons
Right, they're coming
how
up
to
with the
fund the asset in a way that it's an offshore company, how to fund it in a way to minimize U.S. tax. I see my time is up, so unless you have further questions, I don't think I'm in a position to say more. Thank you.
Did I read the wrong complaint?
No, you read the right complaint, Your Honor. In fact, I'd refer to paragraphs 49 to 51 in particular. The allegation is that KPMG designed the demand note scheme as a way to hide platinum. That is the allegation in the complaint.
I thought the sense I got with the allegation is that they were approached, KPMG was approached, how do we do this? Here's how we can do this. I mean, that's the sense I get from the allegations, right?
Yes, Your Honor. Absolutely.
That's an affirmative, active act on the part of KPMG in terms of getting this thing going, right? That's where your whole aiding and abetting claim comes from. Versus the Seward-Kissel claim where there was no active engagement, I think.
Your Honor, that was the point that I was going to make. Thank you for making it for me. This is not an omission case. This is an affirmative act being taken in terms of creating the demand note as a way to help Platinum. And it was Platinum that approached KPMG on this to come up with a way to hide their presence and make it seem like there was $100 million in capitalization when there was not. And then it's also an affirmative concealment case because KPMG affirmatively hid Platinum's name when it gave the valuation letter, and that is similar to what this court decided in the Hobigon case.
In a concealment case, there has to be a duty to reveal, correct?
No, Your Honor, I'm going to disagree. This isn't a duty case. It's when there's a duty.
Well, I want to get, I guess, and really where I'm having trouble, and I think it really has to do with what I was trying to ask your adversary, the duty of disclosure here really flew from Beechwood to your client, right? Does there have to be a similar duty in order to have aiding and abetting the fraud?
Absolutely not. This is not a negligent misrepresentation claim. Aiding and abetting fraud has 3 elements. So, for example, if I may, and I apologize for going over my time.
I'll let you answer my question.
But if I go ahead and hire a locksmith to help make keys for me to break into a building, The locksmith is never getting anywhere near the building, has no duty to the building, but he is aiding and abetting. And if you look at the decisions in William Doyle, Gansett 1, and Osterer, there was no duty between the plaintiff and the defendant. It's the act of an underlying fraud, actual knowledge, and substantial assistance, all three of which have been pled here. And to finish up, yes, I recognize 3016B requires fraud to be pled with particularity, but the Court of Appeals in Pluderman has made it clear that the generalized allegations are sufficient, and here you have extremely detailed allegations that give 5 types of substantial assistance and 5 types of actual knowledge. Thank you, Your Honors.
Thank you. Thank you both. The next case for argument is DeGraw Construction versus HPDC2 Housing. You may proceed, Counselor.
Good afternoon, Your Honors. Stanley Schlein, representing the appellants in this matter. I appreciate the time given to me by the court. The matter appealed to here relates to a period of course of conduct actually engaged in between April of 2012 and June 2012 regarding the construction of an affordable housing project in Bronx County. In fact, the litigation that ensued involved whether or not 4 change orders should have been approved and paid for by the respondents, the defendants in this action. And we believe that the court's determination that they should have been was completely an error and erroneous in its determination of both its interpretation of the contract and of the facts presented at trial. In fact, the plaintiff, DeGraw Construction, abandoned the job and in fact never completed the work that they were contracted to engage in. They were obligated to complete concrete and rebar work in a 2-month period from the commencement of their contractual obligations. After 6 months, only 50% of the work was completed, and it was completed in a faulty manner. And they, in fact, abandoned the job at the end of June of 2012. Shortly after their abandonment of the job, the New York City Department of Buildings shut the job down, issued a stop work order based upon their faulty work. And during the trial, in fact, when these facts were presented and the judge rejected them, the judge also rejected the demonstration by defendants that this same contractor had previously engaged in the same course of conduct in another job and was tried and convicted of a federal crime in that endeavor. This is not an uncommon action by DeGraw. Nevertheless, after abandoning the job, they submit a $600,000 plus $600,000 change order, which was never approved or demonstrated that should have been approved by the defendants. The contract clearly stated and was obligated to have all change orders approved by the contractor, the subcontractor, the defendants of this action, before being paid. The appellant said none of them were done, none of them were approved, and no appropriate documentation was presented for their approval. It is argued by the respondents to this appeal in their brief that, in fact, there were there were requisitions of payments that were approved. Those requisitions, Your Honors, were encompassing both the change order amounts and the actual contractual work. Only the contractual work was paid, never the change orders, and not one change order was approved. I thank the court for its attention to this matter. Our memorandum of law brief speaks for itself. We ask the court, obviously, to review the record in this matter. Thank you.
Thank you. The next case is Ramos versus Goldberg Scudieri. You may proceed, Counselor.
Thank you, Your Honors. Good afternoon. My name is Shalom Prager, and we represent the plaintiff appellant Raymond Ramos in this action. As this is an appeal from a malpractice case, we must look at the underlying facts of the previous case. The main issues on appeal is whether or not the trial court erred when dismissing Mr. Ramos's malpractice claim. As Your Honors are aware, Mr. Ramos, and as our brief points out, Mr. Ramos was represented by the respondents as attorneys in 2 actions relating to Mr. Ramos's ownership of his apartment. 2 actions were a holdover proceeding and a declaratory judgment action, seeking to show that Mr. Ramos was the actual owner, in fact, of his apartment. Defendants made 2 glaring mistakes, and I'd like to take each one in turn. The first one was with respect to a so-ordered stipulation that they had signed, essentially tying the holdover proceeding.
Yeah, I don't understand why that seems like such an error. I mean, it seems to me, in the motion court actually pointed this out, they were interrelated cases. They both concern the underlying issue of whether your client was a legitimate shareholder of the apartment, and whichever way one or the other went, it was going to be binding in the other action, wasn't it?
Well, I do believe that respondents touch on that on our brief, and we respond to that in our reply brief. However, with regard to the 2 actions being tied together, the bigger issue at hand was that the fact that one of them was time barred. And with respect to that...
It was time barred, and also the court went on and substantively addressed, after a 3-day trial, the genesis of your client's claim to ownership of this apartment. I mean, it wasn't like your client didn't get a full and fair hearing about whether he owned this apartment or did not.
Well, I would just say with respect to the trial, that is the second issue on this appeal, the fact that respondents completely failed to call a key witness at the trial, which was the only other person who was present at the closing for the apartment.
What would she have said?
Well, she was the attorney who
I
was...
understand, but what would she, unless she would have said that she witnessed the signatures, was she in fact the notary on the signatures that the transferees claimed were fraudulent?
So I don't know, obviously I don't want to put testimony into her mouth.
So without that, what could she say?
Well, what we believe what she would have said is that the transfer actually took place, whether or not, I believe that there's also...
The claim was that the transfer was a fraud, that the documents that were signed purporting to transfer the apartment were a fraud that was basically inopportune by your client's mother.
Well, with respect to that, I do believe that there was a fraud claim then that was brought, which was dismissed as well against our client in terms of that. So, well, again, with respect to what Miss Anna Stern, who was the attorney present, and I see that my time is up.
You can't say what she would say. We don't know.
Right.
There's nothing in this record that indicates what she would say other than that she was physically there. Okay, thanks.
Thank you.
Proceed.
Good afternoon, Your Honors. Karen Lager from Marks O'Neill for the respondent. Very quickly, I just want to point out, we believe that the court properly dismissed the complaint in this action. There was no but-for causation, which is a necessary element of a legal malpractice case. With regard to the purported testimony of Anna Stern, there's actually on page 150 of the record, there is a letter from Miss Anna Stern where she has no recollection of even attending the closing in question. I think the underlying court and the trial court was very clear that the purported, they would not participate in the purported fraud that was
We don't have anything that indicates that she notarized signatures or vouched for the authenticity of the documents that were proffered in terms of authorizing the sale of the shares and the signing of the lease.
No, Your Honor, you're correct. And in fact, the letter demonstrates that she had no independent recollection of ever even attending this closing. And, a strategic decision is not legal malpractice, whether or not to call a specific witness at the time of trial. The underlying trial court's decision was pretty clear after a 3-day bench trial that there was sufficient evidence to demonstrate that the appellant was never the owner of the shares. And certainly the res judicata would have tied these cases together, whether or not they had stipulated to the holdover proceeding.
The Supreme Court, regardless of the statute of limitations, went ahead and resolved and decided the merits of the case.
Correct. So they certainly gave the plaintiff in that case a fair opportunity, regardless of the issues of latches. Thank you.
Thank you. Thank you both. The next case is Niche Music against Orchid Enterprises. Niche Music. You can proceed, Counselor.
Excuse me, Your Honor, what did you say?
You may proceed.
Okay. Thank you, Your Honor. My name is Stephen Fairchild. I represent Niche Music, the plaintiff appellant in this litigation, and may it please the court, I'm here to request that this panel vacate the lower court's ruling of summary judgment that was entered against my client. And there are numerous factual and legal disputes between the parties, but I think there are two major issues that separate them. And the first issue is whether or not the first BHS contract was properly terminated. And we believe that it was not. That under both, well, first of all, California law applies, but under both California law and New York law, the express rule or the express terms of the contract are controlling. And we recognize there was a dispute, a factual dispute between what happened when Orchard, or I'm sorry, the BHS requested that Niche take down their music. However, these are course of dealing situations, and
The contract that we're looking at is when we're talking about the breach of contract, is a contract between Niche and Orchid Enterprises, right?
they are both successors in interest to the agreement, yes.
Right. Correct. Right. There were a lot of different iterations. So in that contract, there was no non-compete clause, was there?
It's not expressly written, Your Honor, but we believe that it is reasonably construed, given the language that the agreement says that they will use their best efforts to promote Niche's catalog, and as well as to coordinate with promotional opportunities.
But that's an issue of contract interpretation, and even if we allow, maybe there is, maybe there isn't. In January of, I think, let me see what year it was.
2015, I think, probably.
2015. You write to Orchard and you say, we no longer have a contract with BHS, and you're to stop promoting their music on our behalf, correct?
I believe that's what it says, Your Honor, yes.
Yeah, so under those circumstances, how can their entering into a contract that begins after that date otherwise be a violation of any kind of implicit or explicit provision of a contract that you have with Orchard?
Because the BHS sent a notice that terminated the wrong contract, and under the express.
But isn't that between you and BHS?
Yes, it was.
Right, so what does Orchard have to do with that?
Well, Orchard,
They violate their agreement because BHS shouldn't have terminated your agreement. You told Orchard, we're terminated.
we believe that was a mistake that on the part of
What
Ms.
was a mistake? You're telling Orchard that you were terminating the contract?
Well, all parties misunderstood that the wrong agreement with BHS was terminated. It wasn't realized at the time.
Did Orchard realize that? Because they got the email from you saying our agreement with BHS has been terminated. Weren't they supposed to rely on that information that they got from you?
Well, I don't know what Orchard knew at the time.
So I'm sorry. So again, are you stating that your email was incorrect?
Yes, it was.
And so how would they have known that it was incorrect once they received it?
Orchard?
Yes, that's who you sent it to, right?
Well, I don't think they would have had the BHS contract, on file with them, so I don't know how they would have known. But regardless, that the express express terms of the first BHS contract required 30 days notice of the termination of that contract, which never happened.
But
It's
you're
the
not
termination.
suing BHS here.
I'm sorry?
You're not suing BHS.
No, we're not.
Okay.
And the second issue I wanted to discuss was whether or not California law and policy forecloses the covenants not to compete. The lower court's order assumed that it was, but there are numerous situations where under California law that they do allow covenants not to compete, and the lower court did not consider any of them, and we believe this was an error. And it's fully discussed in my other brief, and I thank you for the court's time.
Thank you. You can proceed, Counselor.
Good afternoon, Your Honors. My name is Jonathan Davis. May it please the court. I act on behalf of Respondent Orchard Enterprises New York, Inc. We seek the court to affirm the judgment below, granting summary judgment. I think the court's initial response
Hang on a
to
second.
this.
Your client, you guys get an email from the appellant saying, our contract's been terminated by BHS, stop promoting them because we're done with them. And then I think your client gets approached by BHS, correct?
Your Honor,
You don't actually reach out to them, they came to you.
Yes, the client, BHS, was introduced to us by a third party in September, months before the termination of the actual agreement. There was a provision in the contract that required 30 days advance notice before the end of the term in which to terminate. That was done on September 30th, 2014. There was an introduction made by a third party, and a contract was entered into with Orchard with BHS in December of 2014 with a start date beginning after the expiration of the term of the agreement with Niche, the appellant. Yes, Your Honor. So
was there a non-compete clause at all in the contract?
no, Your Honor, and that's a red herring in this case, because what the appellant is attempting to do here is construe such a provision in an agreement that has nothing to do with that type of action. What appellant argued below, that there were a few provisions within the agreement cobbled together where one could be implied. Under California law, except in very specific circumstances, are non-compete agreements permissible. But again, it's a red herring because there was no competition here or anti-competitive behavior, because the agreement between BHS and the appellant was properly terminated by notice. Yes, the wrong contract was referenced in the letter of termination, but as one of the justices pointed out, in January 2nd of 2015, It was identified by John Clunas, the general counsel and original founder, one of the founders of Niche, that they had lost the right to continue to distribute music digitally on behalf of BHS, and they asked Orchard, to take down all of the digitalized recordings that were being exploited throughout the world, which they did, which they were contractually obligated to do. Now,
Notify you, right.
yes, and we acted on that.
Right, and if they did that, as your counsel's adversary said, by mistake, does that change this in any way? Does that change the impetus here?
It wouldn't, Your Honor, because the contract was terminated by everybody's understanding. What appellant attempts to do is to argue this issue of parole evidence, saying that looking at that January 2nd email from Mr. Clunas, the general counsel, is the court looking at parole evidence. We all know that parole evidence is looking at prior conduct or documents in an attempt to interpret a contract. There was no dispute with respect to what the provision in the Niche BHS contract said with respect to termination. It required a written notice in order to terminate. The documents that the court looked at, and which this court has looked at, the January 2nd, 2015 email, only was a confirmation of the understanding that Niche had with respect to BHS's conduct to terminate the contract.
So what about the second claim that they had, which is tortious interference with business? Does it matter that your people met with BHS before they actually terminated the contract with Niche?
Well, that's not an admitted fact or one that has been determined in this case.
I understand,
Yeah.
but it's summary judgment, so...
Right, well, I don't think it makes any difference. So long as we didn't interfere with the performance of the contract that was between, and I say wrongfully interfere, as long as we didn't do that, it wouldn't matter what conduct the Orchard engaged in, because, in fact, they were involved in the musical distribution of the catalog that Niche had secured from BHS. So there could have been, and might have been, conduct between them, but there was no act, nothing that the appellant has pointed to that shows any wrongful conduct on behalf of Orchard in connection with its communications, if any, with BHS. The issue on tortious interference really is there was never a breach. Appellant has claimed all along that the wrong contract was terminated. And if that's the case, then where's the breach here? There could be no breach. Are they saying that we induced the breach of the contract that is not the subject of their concern? And more importantly, a point that the court below didn't get to, but could have, is that the statute of limitations with respect to the tortious interference claim has expired. If you use any measuring stick that would be applicable in terms of determining the accrual
let's use
date.
January 2nd, because it could be no later than that.
Precisely, Your Honor. So the action here was commenced on January 8th, 2018. They were out of time. So even had there been a tortious interference claim that was viable, it would be dismissed based on the statute of limitations. So that is the end of the game for them with respect to that claim. And with respect to the contract provisions, because the primary claim that they alleged was with respect to a breach of the IOTA agreement, the agreement between appellant and respondent. Justice Sherwood went through every component of the breach of contract claim and addressed why each claim was not viable. He shredded it. And that was the end of the case, with both claims now not able to proceed.
All right, thank you.
Your Honor.
Okay, you can proceed with your rebuttal.
Okay, thank you, Your Honor. Just a few quick points in response to what he said, that the the covenant to not compete is not a red herring at all. We also allege that there was a breach of the covenant of good faith and fair dealing, and this goes into that as well. The covenant to not compete spans into that, regardless of whether or not it was the covenant not to compete was expressly in the IOTA agreement. And I just want to point your honors to page 19 of my reply brief, where I talk about the California Commercial Code, which makes it very clear that the express terms prevail over the course of performance, course of dealing, and usage of trade. So whether or not parole evidence is a factor in all this, it's irrelevant under California law when the express terms of the contract mandate that how the BHS agreements were to be terminated, and the second BHS agreement was terminated, and not the first.
Well, what do you respond to how do you respond to your adversary's argument that they're not seeking parole evidence to show what was intended by the contract? They're just showing basically a performance, a termination.
It goes to the course of dealing of the two parties, which under California law is secondary to the express terms of the agreement.
Okay.
Okay. Thank you, Your Honors, for your time.
Thank you. Okay, the next case for argument is Curacao Oil versus Trafigura. Good afternoon. You can proceed.
May it please the court. My name is Gina Venesia, and I represent plaintiff Cure Oil. This case stands before the court on a pre-answer motion to dismiss on documentary evidence. As such, Cure Oil's allegations are to be accepted as true, and all inferences drawn in Cure Oil's favor. When the entire record is examined closely against the applicable standard and the factual error of the Supreme Court corrected, the dismissal of the contract and warranty claims cannot stand because the record and the inferences drawn therefrom do not conclusively and definitively dispose of Cure Oil's claims in their entirety. Far from it. The Supreme Court's decision allows Trafigura, the seller, to frustrate the very essence of the sales contract.
I'm reading the quantity and quality, the determination of quantity and quality provision of the contract. And it's pretty, to me, it's pretty clear. It says once the inspector who comes out with a decision, that's final and binding. An independent inspector, and in this case here, the independent inspector, as it turns out later on, was inaccurate with his report. But there's no allegation that the independent inspector, there was any fraud or anything involved in that. So how do you get around that? I mean, it's final and binding for all purposes, so that afterwards, after the inspector gives the report, you find out later on, because of complaints that you're getting, that the oil received from the defendant was contaminated. How do you get around this problem?
Yes, Your Honor, I think you drill down to precisely what the issue here is. The issue here is whether Clause 12 in the single-page certificate issued by Intertech conclusively and definitively excludes the claims presented in this case. We submit they do not for the following reasons. First, general contract principles. You got to read the contract as a whole. You got to give effect to all provisions. Secondly, Clause 4 is the warranty provision. It says the fuel shall be as per ISO 8217. No qualifications in Clause 4. ISO 8217 includes multiple requirements. Those requirements include...
I understand that. I get that. That there are certain levels of inspections or that you have to drill down on for this oil product that you're purchasing. But are you asking if I were to agree with you, I would be writing into this contract a provision that doesn't exist.
I disagree, Your Honor, because Clause 12, if you look at Clause 12 and pull up the certificate that was issued by Intertech, it's record page 61. And
Right.
Clause 12 is
I
all
understand
about,
what the inspector wrote, the report they wrote, did not talk about the contaminants that you found.
and it didn't say it was compliant with ISO 8217. It does not state that. You can look at,
And
look
how
at
do you
the,
get around the for all purposes provision in your,
because
in the
Clause
contract?
12, if you read Clause 12, and you look at that in
I
the
can't
context.
read Clause 12 to the exclusion of the all purposes language in this
Because
in this
we
contract.
submit that all purposes is with respect to those characteristics that were tested. And the reason for
Yeah, I
that,
got that
Clause
argument.
12 says determinations. It refers to his determinations. And if you look at his determinations on the page, record page 61, his determinations are only about ash content, sulfur, water, those types of things. There is no determination on that entire page that the fuel is compliant with ISO 8217. It is not there.
Then why didn't you have, or why, I mean, I would presume that the parties involved in this contract here, this this purchasing of oil, this is nothing new. Why isn't it then that you insert something in the clause there that gives you that opportunity, saying, you know what, whatever the inspector comes up with, that's only a condition approval, we're going to do our own, and if it fails, all bets are off. Why isn't that written in
Because
there?
I don't think you need it. Because the ISO 8217 contemplates this concept of doing limited testing.
Or is it that you don't have that because you will wreak havoc in the oil industry if you had that kind of language in that?
That is not correct, Your Honor. That is not correct. 8217 provides specifically that marine fuel shall be free of deleterious materials, shall be free of materials that make it unacceptable for marine uses. And you cannot do that kind of testing in the short period of time when vessels arrive at the discharge port. It is accepted in the industry, and that's why.
Accept that, and we have no reason not to accept that. Shouldn't the contract have reflected that to say in paragraph 12 that the inspector is inspecting only for the purposes of the tests which he is going to conduct, instead of the all purposes? What does all mean? All purposes.
We submit that it means in the context of this case, when you look at the whole contract and look at what the inspector did, that he's collected copious amounts of sample material. That is the sample material that was tested. Cure Oil didn't collect its own samples.
We understand the facts here. I guess it's really what we're grappling with is the contract, which seems to be, at least in its plain reading of it, at odds with what you're asking us to do, when it could so easily do what you wanted to do with the right language, right?
I think, Your Honor, you have two possible interpretations. One is that final and binding is with respect to all matters, tested or not tested. Who cares that there's additional sample material that was taken?
Not all matters
and
as
then
to the quality of the oil.
quality as tested, the parameters tested. And the other alternative interpretation is that final and binding was with respect to the testing that was done at the discharge port while the vessel is still there, limited testing.
I wish that the clause provided that. That would make our jobs easy.
You're talking about the context, and you specifically said the context of the facts presented here. That's not what we're concerned with necessarily. We're not necessarily concerned with what the facts here. We're concerned with the contract and the context of the contract. And the contract says final and binding for all purposes. And so wherein it may have a result that you don't agree with or you don't like based upon what actually occurred here, that's not the determination that's to be made.
Well, Your Honor, I agree. Clause 4 does not say final and binding for all purposes as tested. Excuse me, Clause 12. Equally, Clause 4 does not say, as per ISO 8217, only Table 2. It says all of ISO 8217. So we submit, when you look at everything as a whole, the case should not be dismissed on documentary evidence.
Thank you. You may proceed.
Thank you. Good afternoon, Your Honors, and may it please the Court. My name is Francis Healy with Strzok & Levan on behalf of Defendant Respondent Trafigura PTE Limited. Dismissal should be affirmed for several reasons.
She makes a good argument that for all purposes means it means for the purposes of what the inspector inspected or what the inspector examined. it should not cover areas that that the inspector didn't go into. So therefore, it was wrong for the court to dismiss this case.
Well, I would respectfully disagree, Your Honor. The language is final and binding for all purposes, save for two very specific exceptions:
Right.
fraud or manifest error. Neither of which
On the
are
inspector's part, on the inspector's part, correct? Fraud or
not necessarily. There could be, take for example, fraud. If a seller intentionally knew that the fuel oil was contaminated and then made a material misrepresentation with the intention to induce the buyer to purchase that.
Got it, right.
And if those facts were there and there were enough facts to support that allegation, that could be a fraud exception that falls under that Clause 12 exception.
Well, then what's the remedy under the contract for non-conformity with the ISO 8217 standard, which is referenced in the contract? What's the remedy?
Well, there is no remedy applicable here because the fuel complied with the standard. If you look at the quality clause in Section 4, it's as per ISO 8217, and when you look at the inspection section in Section 11 and the determination language in Section 12, it's clear and we think unambiguous that the determination of the inspector, as reported in the certificate of inspection, was quality of the product as a whole, and that encompassed all of ISO 8217. And when you look at the actual standard in ISO 8217, all of the tests that were required to be tested, and they're included in Table 2 at page 91 of the record, they were all tested and they all come back in compliance with the respective limits. So the fuel absolutely complied with all of the requirements of 8217. And to my adversary's point, the only determination that was made here, the only determination that could have been made by the inspector, was with respect to the quality as a whole.
Is this an industry-wide provision?
It's a fairly standard provision, Your Honor.
Standard provision, right? So
Yes,
what?
and
So
it's not in every contract, but it's there for a reason, and it provides the seller with certainty and commercial certainty so that they're not exposed to risk, down the line.
yeah, because it seems like the inspector report is it. That's the cutoff point in terms of the seller's liability, right? Once you get the inspector report, it says you're good to go. That's it.
Absolutely correct, Your Honor. And to your point before, Cure Oil, the plaintiff here is a sophisticated oil company that enters into thousands of transactions a year. It concedes that it was very familiar with the ISO standard. It was familiar with what was going to be tested as well as what was not going to be tested. So if it was concerned about the presence of deleterious substances later on, it certainly could have and perhaps should have negotiated or tried to negotiate additional exceptions to that final and binding language. For instance, final and binding for all purposes except for fraud, manifest error, or indication of the presence of deleterious substances later on.
Did I read somewhere in Supreme Court's decision where he says, or at least in the record here, that things had to move very quickly when these ships come into port with the oil? There's just you just have to move very quickly in terms of getting the inspection, get it done, get it approved, and so the transaction can close?
Certainly, that's partially true. So there are certain tests that can be done within a day and you get the results back quicker. And those are the tests that were immediately done and reported in the certificate of analysis. And the test on which Cure Oil relies for, and we don't concede this point, but for the presence of deleterious substances requires an additional test, a GCMS.
Which goes to my colleague's point that could be written in the contract.
Absolutely. And to further to that point, it doesn't take multiple days or weeks to take that test. It takes a couple of days. So yes, it could have taken a little more time, but if you look at the contract, discharge was over 3 days at port. And certainly, if it was that important to Cure Oil, it could have negotiated for that test to be done, and it could have been done in 2 or 3 days and satisfied any concerns that it had. So obviously, our position is Cure Oil is trying to read into the contract a provision that it wished it had negotiated, but is not there. To another point, my adversary pointed to, and in their briefs, she points to the fact that there were extra samples that were there, and that somehow indicates that the parties contemplated the prospect of additional testing down the line, and that's just not the case. The additional samples are used for testing only as prescribed in the contract, and that's clear and unambiguous. and that's only in the instance of fraud or manifest error.
Counsel, how long after the fuel was discharged did the plaintiff complain to Trafalgar?
So that's a good question. It was over a month later, months later, and that, we obviously think the Sempra case is controlling here. It's directly on point, and if you compare the facts of Sempra with what we have here, is under Sempra, the testing was done, and then within days, I think 3 days later, that subsequent testing was done. And it was done by the same inspector of the same sample using the same test methodologies that were agreed. And this court still found that that second test result was not material under the language, the same language we have here. And you contrast that to here, where the subsequent testing was done a month later using a different inspector that was unilaterally appointed by Cure Oil, and was using a test method that was bespoke, in-house, and was not standard or agreed to by Trafigura. So under those circumstances, certainly and under Sempra.
Getting back to my colleague's point, so the remedy here is there's no remedy for the plaintiff. They're stuck with a bad product. I mean, it's buyer beware, and you're too bad. I mean, that's the sense I get, right?
Correct. Under the contract as written, and in New York, clear and complete contract has to be enforced according to the plain meaning of its terms, and that's what the parties agreed to here. So thank you very much.
Thank you.
Thank you, Your Honors. A couple of points. My opponent says that we are trying to write additional language into the contract. We submit, Trafigura is trying to write out the incorporation
No,
of
counsel, I have to ask you a question. I mean,
Sure.
and to follow up on the remedies part, you could have put in here a provision that provided you for remedy if later on you found something that wasn't compatible to your purchase. In other words, if you later on found out it was non-conforming, you could have had a paragraph in there saying for demand back from the defendant of whatever you paid. You could have done that, right?
Could
I mean,
have,
just
but
in
not
terms of-
necessary.
I'm sorry?
Could have, but correct, not necessary. And the question is, there again, as I said,
It's
there was-
shifting of the risk, though, so you could have done that.
disagree, Your Honor, because we had the strength of an express warranty. It's an express warranty. This
understand
shall
you
be
have the
as
express
per
warranty.
ISO 8217. And I fail to see how, he says he discounts the idea that copious amounts of sample material was collected. At the instruction of both parties, that material wasn't destroyed or dispensed with after this initial testing, after
I'm
the
just-
vessel sailed
counsel,
away.
my
It's
question
still
is just
sitting there.
Right. The purpose of my question is that the fact of the matter is you could have inserted in this contract here with the defendant a remedial provision in case something went wrong.
I do not disagree, Your Honor, I do not disagree with you. Yes, the contract could be more clear, but that doesn't mean the opposite holds true, that we have no remedy. We do have a remedy.
Okay.
And ISO 8217 was incorporated in its entirety. The parties understood.
You have a
as-
remedy if I agree with you.
Yeah, and the parties understood, based on their practice, based on what happened, that additional testing could be done, and it's not the same parameters that were tested. Sempra is irrelevant. Sempra is not directly on point. We did not test the same categories or the same characteristics that Intertech tested in that immediate time period. These are deleterious materials. They require deeper chemical analyses. The parties contemplated that that would happen. The contract contemplates it, and therefore we submit that dismissal of these claims was inappropriate. Thank you very much for your time.
Thank you both. Right, the next case is U.S. Bank against Olatunji.
Good afternoon. May it please the court. My name is Robert Link. I am counsel for the respondent. Being it that my...
Never showed up. They're not here?
That's correct, Your Honor.
All right. They didn't notify you?
I suppose not. Being that my adversary is not here, I'll keep my comments brief and
Well, you
whatever.
only have 3 minutes anyway, so go right ahead.
The prevailing factor in the trial court's determination both the special referee, Referee DeBola, and Judge Gonzalez was that the appellant defendant in this case had no credibility, that she repeatedly contradicted herself, that she submitted affidavit testimony that said, quote, "I have always lived at College Avenue," that throughout the transcript, throughout the Travers hearing, the defendant appellant repeatedly mixed up whether or not she lived at the College Avenue location or in the Wakefield.
Well, credibility did play into this. As I understood the decisions of both the referee and the court, was that although your client was now, not your client, although the appellant was now claiming that she lived in the basement apartment of the premises of this one family dwelling with a separate door, that nobody knew that and there was no way to otherwise tell. So when the process server went to the front door of this one family house, they were entitled to serve the adult who came to the door.
Precisely, Your Honor, and the court cited Roldan v. Thorpe, which was a Second Department case, which is that the outer bounds extend to the front door when there's no overt distinction from this, what is ostensibly an illegal basement apartment that you can't really tell just by the looks of your eyes, and the front door of a single-family house. And I wanted to point out in the record at page 113, the admission that this was a single-family house as opposed to the multifamily or apartment building cases that were cited by my adversary.
And she never identified that she was living in the basement apartment on any of the documents that were part of the mortgage.
Certainly not, to my understanding, Your Honor. It's certainly not in the record here that's in front of this court. With that, I'll withdraw the rest of my time. Thank you so much.
Thank you. In the last case for this afternoon, Doe v. Doe. Appellant. All right, you can proceed.
Thank you, Your Honors, and may it please the Court. The record shows that the respondent in this matter does not have a substantial privacy right which outweighs the constitutionally embedded presumption of openness of the courts. The respondent in this matter does not have a statutory privacy right. The record is void of any substantiated facts proffered by the respondent that this court could even weigh that there is some privacy interest at issue that would outweigh the presumption of openness. In fact, the lower court did not did not engage in a common law balancing of privacy interest versus the public interest in open courts. The court simply stated that there was this compromise, that both parties could be anonymous in this proceeding.
Was there a compromise? That
There was
both
not a
parties would be anonymous?
No, there was not a compromise. And the record shows that the plaintiff in this matter had, from day one, had properly petitioned pursuant to the Supreme Court, New York County had petitioned to be anonymous and had never petitioned for the respondent to be anonymous. And that is that, and
Well, even if she had, the respondent's not covered by the statute.
correct, Your Honor. And so the respondent in this matter is claiming that the harms to the respondent are embarrassment, reputational harms, all harms that we have seen in the Supreme Court, in the lower courts, and at the appellate division do not amount to allowing for a privacy right. when it comes to cases involving claims of sexual violence. So at the appellate division level in New York, we do not have guiding precedent when it comes to a defendant's rights to privacy and claims of when there's accusations of sexual violence in a civil action. However, there are sister jurisdictions at the appellate division level that are on point, and in the Supreme Court First Department, there's a lot of discussion when it comes to the defendant's anonymity. So that's what's at issue really here, is this, I mean, that's all that is being appealed, is that this respondent defendant does not have a right to proceed anonymously. Right, so turning to
You believe that the trial court employed the wrong standard.
Correct.
Right, it wasn't a compromise, it was a balancing test that had to.
Right, and there was not.
Care of.
Sorry, Your Honor. I'm so sorry, Your Honor. I could not hear what you had last said.
Just that there was no balancing here of the different factors.
Correct. And there's no, and looking to other jurisdictions to find some answer on this, there is no carved out privacy right for defendants in sexual assault cases. No one wants to be.
They get looked at in the same rubric as privacy in any cases in which we have an anonymous caption.
The defendant.
The defendant. Your client has a statutory right. That's different. We put that to the side.
Correct.
In the absence of a statutory right, we do have parameters about when we will give an anonymous caption. Right? And those apply regardless of whether, there's no special category for a respondent in this particular circumstance.
Correct, Your Honor, and the record is void of any
special circumstance.
Special circumstance. And even in the respondent's brief, I mean, he argues just that the basic, simply because he's being accused of rape, that in and of itself is self-evident that he should be anonymous, and that actually goes against the public interest of what we're trying to do.
Well, I think they're going a little further. They're saying that this matter was investigated by the DA's office and police department, and they felt that it was not necessary to bring any charges against the defendant. So the argument goes, no charges were brought against me, so why should I be exposed and have my name on the caption so that everybody knows that I'm being accused of having committed a rape?
And that's why in the brief, in the appellant's brief, we explain that that these privacy rights are not contingent on a criminal matter. This is the civil litigation, and it's dangerous to have a precedent set on the criminal case. As we know, that's a completely different burden of proof. That's a different it's a different burden of proof, and there's no case law supporting that if the defendant is being accused of a sexual assault, that somehow is self-evidently entitles the defendant to anonymity. And in fact, in TSR VJC, the Appellate Division New Jersey case, it is a case on point where the defendant even argues substantial harm, to his family, to having these egregious accusations, and the court still found. But we have a public interest in knowing who's being accused of crime, whether it be crimes, whether it be malpractice cases, if there's ethical violations. There is a public interest in knowing who is being accused. And that's why there's such a difference. That's why Appellate went into such a broad discussion of the privacy interests for those that have been alleging that they're victims of sexual violence versus those that have been accused. Not sure how much time I have left, but briefly that also the court did seal this matter, and there is no basis for the sealing, and the judge in this matter, pursuant to statute 22 NYCRR 216.1, there has to be a showing of good cause, and the lower court judge simply cites to its memorandum opinion that to show good cause, and there is nothing about sealing. The appellant, the respondent, did not request a sealing order. In fact, the case law that the judge cite, Anonymous v. Lerner, that was a case that was not sealed. In fact, that was a case where the plaintiff was not permitted to proceed anonymously. So a finding of a sealing and limiting public access to the courts was unfounded. And that's mainly, that's the basis. We want open courts. We want to know who's been publicly accused. Whereas separately, we have found privacy rights for those that have alleged they are victims of sexual assaults, and that does not extend to defendants in these matters. Thank you, Your Honors.
Thank you. You may proceed.
Thank you, Your Honor. May it please the Court, my name is Matthew Galuzzo. I represent the respondent, John Doe, in this matter. The first thing I want to say is that this case was decided in a manner that was fundamentally fair, that it was not an improvident exercise of the discretion of the trial court. The trial court was well within its discretion to rule this way and put both plaintiff and defendant on equal footing going forward.
But they're not on equal footing in that there is a statute which allows the plaintiff to proceed anonymously, but there's no statute that would allow the defendant to proceed anonymously.
Your Honor, I would encourage you to read the approximately 24 citations from trial courts across this state who have disagreed explicitly with that opinion. They have said time and time again.
What about courts here in this jurisdiction?
In this jurisdiction as well, Your Honor, time and time again. Yes, time and time again, 50B covers civil plaintiffs if and only if that particular plaintiff is a witness in a criminal case or going to be a witness in a criminal case. Here, like for example in Doe versus Kidd, a case that I cite from this New York County Supreme Court, and several other cases as well, page 13, page 16 of my brief, if there is no criminal case, then they are not entitled to anonymity under 50B. Now,
You're talking about the plaintiff.
You're mixing up apples with oranges. You didn't cross appeal. So the issue of whether the plaintiff here is entitled to anonymity is really not before us. So let's deal with your client.
Yes, that's correct, Your Honor.
I'm dealing with your client. I'm not dealing with the plaintiff. If I said the plaintiff, I misspoke. I didn't think that I said. What I thought I said was that the plaintiff was protected by statute, but your client is not protected by statute.
And I'm saying that's incorrect, Your Honor, because she is not a witness in a criminal case. The criminal case is
Okay, I'm sorry. Your client. I just want to deal with your client.
Yes.
Where statutorily is your client protected?
My client does not have a statutory protection. Neither does the plaintiff.
Okay, we're not.
Neither does the
I'm
plaintiff.
sorry. Forget the plaintiff. We're only dealing with your client. I apologize. I don't want to put that out there. That is not before us. Your client.
Your Honor, so because she is not statutorily entitled to it, and neither is my client, the correct analysis for the court.
One has nothing to do with the other, Counselor. Please.
Yes, but what they are supposed to do is evaluate the different elements from anonymous versus learner, for example, a decision from this court on anonymity applications. You're supposed to consider a number of interests in balancing the application of anonymity for all the parties that are concerned, whether it's a plaintiff or a defendant. And in this case, there's no reason why there should be an imbalance in the anonymity and the captions.
There was no balancing done. We're talking about two different things. I actually agree with you that with respect to your client, in the absence of the statute, that what the court was required to do was to balance the openness of a courtroom with the interests that your client was seeking to pursue in terms of privacy. Was that done here?
Yes, Your Honor. Yes, it was.
How was that done?
Yes, this is how it was done, Your Honor. My client counterclaimed a malicious prosecution counterclaim in his response to the complaint. And in that, he alleged that he was maliciously prosecuted because the plaintiff initiated a prosecution of him that was terminated in his favor when the DA's office decided not to bring charges against him. He also, in that counterclaim, said in his affirmation that he had suffered psychological injuries, emotional damage, all practically the exact same allegations that the plaintiff had made in her application.
But doesn't that's in a malicious prosecution action, that's compensated by money, if he's correct.
That's correct, Your Honor.
We don't routinely, as far as I understand it, give anonymous captions just because somebody is alleging malicious prosecution.
No, that's correct, Your Honor. My point here is that his allegations about the harm that he suffered from this process mirrored hers almost to a T. And on top of it, Your Honor, there is precedent in this.
So your argument is that the balance is what sauce for the goose is sauce for the gander?
That this was fair because both parties are being treated equally with applications that are very similar.
So your
in
argument
substance.
is because he instituted a malicious prosecution claim, that therefore this somehow, a cross-claim for that, this somehow puts him in a position of a plaintiff, and so now they're both plaintiffs and both arguing that they're aggrieved in the same way.
That is close to it, Your Honor. Also, there is precedent. There are decisions I cite in my case, both called anonymous versus anonymous, in which courts in this state, trial courts, have given, one of them sua sponte and another one upon an application, have granted anonymity to defendants who are being accused of some sort of sex crime like this one.
Counsel, I have to ask the question, is that these are based on, your statement is you have these allegations in your counterclaim. Don't you
Yes.
think it would have been a better practice for the court then to hold like a hearing quickly to do the balancing? Because these are all based on allegations, right? Wouldn't it have been the better approach?
It might have been the better approach, Your Honor, but we're looking at an improvident exercise of discretion. I don't think that this was an improvident exercise of discretion. It was reasonable based upon the facts that are alleged. However, should this court think that the record is deficient in some way, you could, of course, remand it down for a hearing by the trial court to make a greater inquiry into whether or not there is a sufficient basis in terms of the likelihood of harm to either party. But I would suggest that that hearing needs to be conducted for the sake of both parties because the plaintiff is not statutorily
You
entitled.
didn't cross appeal, so let's
Okay,
just
very
put that
well.
aside, okay?
That's fine.
I just don't think it's your best argument, okay?
Very well, Your Honor. All right, I see
Can't
my
get
time
what
has.
you didn't ask for.
All right, I see that my time has run out. If there are any questions.
Right, but it's okay, we'll take the time back. We're
All right.
good, right? We understand it. It's an interesting case.
All right, well, thank you very much. I
Okay.
simply ask you to affirm the judgment or at the very least to remand it for another hearing.
Thank you.
Thank you.
Rebuttal.
Thank you, Your Honors. And as Your Honor has stated, the balancing was not done when it came to the defendant respondent.
So here's my question to you, though. You know, if the balancing wasn't done, is the remedy here to just send it back for the balancing to be done?
As you stated, the plaintiff's anonymity was not appealed. That's not an issue with the defendant.
Here.
Right. I mean, there's two things. One, there isn't a statutory protection. And even at the Court of Appeals level, there needs to be some statutory protection for a defendant. And in addition...
Well, I thought you acknowledged that he may have a common law right. He may not reach the threshold on balancing. And the question, all I'm asking you is, do we just look at the record up here and say, on balance, he doesn't make it? Or do we say, court didn't do the balancing, that everybody seems to agree, and send it back down for a balancing?
But there's nothing on the record that's been offered to even engage in a balancing. I mean,
So your answer would be no?
Correct. And even as the respondent says in its briefing, that, as I said, that he's, simply because these are allegations of sexual assault, the quote, and that should not require much further explanation, that was simply enough. And the courts in the Supreme Court, in the First Department, Judge Silvers repeatedly talked about, I mean, it's hard to bring up this issue and talk about this case without discussing public interest. And so much of that is because we have this public interest in knowing about the accused. And that's why there's such a serious discussion in these recent cases about plaintiff's anonymity and about anonymity when all these cases have been brought forward under the Child Victims Act. But I see my time has ended, so I thank you all for your time.
Thank you. I thank both counsel.
Please rise.